In progress.
Good morning, everyone.
Good morning.
Good morning, Ashley. Good morning, Lauren.
That your friend?
We have 27 participants so far. We'll wait another couple of minutes and we'll get started. I appreciate all of you who show up for these Monday morning with your brokers, with your broker breakfast. I wonder about the breakfast piece of it, but we can deal with that some other time. Oh, Kathy, you're there. Wow, that's great. Director of First Impressions. Wonderful. Remember, we have two offices that participate every other week for these breakfast meetings with me and my daughter, Christina, and that's KW Media and KW Brandywine Valley. We welcome everybody from both offices, and maybe we even get to know each other a little bit when we do Q&A and things like that. So I'm really waiting for my daughter, Christina, to appear. Is she here yet? Christina, are you here?
Christina just walked into the market center. She just passed my office. She'll be on in a minute.
Just walked down the hall. She's going to be in the office today. Okay, we'll give her a minute to start up her computer. But I can start by telling you what, by sharing with you what we think is important today. Remember, we ask everybody to participate, but everybody to be on mute until you need to say something. And the topic for today is, I don't know how to say it, is real estate ownership. we have transactional problems when we don't understand who the owner of a piece of real estate is. We maybe list the property and we don't have the correct owners signing on the listing contract. And then to make matters worse, we don't have correct owners signing on the agreement of sale. And to make matters really, really bad, we find out, close to settlement or right before settlement that we don't have the correct owners intending to sign the deed. And if we are the listing agents in that story, we have a goal over our face, not to mention potential big, big problems. And when we have the buyer in those situations where the seller turns out not to be the seller that we think is on the agreement of sale, we have a big problem. And I'm not really identifying some of the topics we're going to be dealing with today. We're going to deal today with joint ownership, but we're going to deal today also with people who have powers of attorney for other people. And is the power of attorney valid? Is it capable of actually being accepted by the title company in order to get through the transaction? We're also going to talk about estates. We're going to talk about executors and executrixes and administrators and administrators, basically all the same thing except a different gender. And an executor is someone who is named in a will, and an administrator is someone who's appointed by the court. But once that's done, which is not overly complicated, not the executor anyway, sometimes getting an administrator appointed if you die without a will can be complicated. So those individuals have the power to list the property, sign a listing contract, and sign an agreement of sale, and ultimately sign a deed. And then we have some, in the past week, last week, we had two fairly serious problems with estates attempting to go to settlement. I think we succeeded in both, but we had estates attempting to go to settlement, and there were unpaid Pennsylvania estate taxes, which is almost always the case. And I'll explain what that is when we get to that topic. So you're not going to get through settlement unless you address that. So when you're dealing with estates, you must address this with the executor or the administrator when you are listing the property, and surely when you're signing an agreement of sale. And even if you have the buyer in these transactions, you're going to want to make sure that the listing agent has had that discussion with the executor or executrix or administrator or administratrix. And then lastly, we're probably going to deal with the rarest of all these situations. Estates are pretty common, and powers of attorney are pretty common. But then there's something else called custodianships. And custodianships are really legally challenging. And most agents don't understand them, and most agents think that a custodian is similar to a to someone holding a power of attorney. And while there are similarities, there are major differences that cause problems when you attempt to sign an agreement of sale, a listing contract, and agreement of sale, but especially when a custodian intends to sign a deed at settlement. That custodian has to get a new court order to get the authority to sign that agreement of sale. To sign that deed, even if the court has already approved the listing and the agreement of sale. The settlement is another step that has to be taken. It's nice if you have competent lawyers involved in these transactions. So those are the things we're going to talk about today, and I suspect you're going to have a lot of questions. Let me clarify something that I think is almost entertaining, but I shouldn't be so cynical. There are many people in the world, and people maybe even on this call, who believe that you have power of attorney for someone when you don't have a legal document. Some people actually believe that husbands automatically have powers of attorney for their wives and can sign for them. And some people automatically believe that that wives have powers of attorney for their husbands. No such thing. The only way you get a power of attorney is by having the legal document drawn up and notarized correctly, and the document has to be drawn up correctly. So that's one issue that people get wrong frequently. But I think most people get that one, that you need a legal power of attorney. But the other one that I find very interesting and distressing is that people think that if they have power of attorney for someone, perhaps mom who's in a nursing home, which is a fairly common situation, that when mom dies, the person with power of attorney still has power to sign listing contracts, agreements of sale, and deeds. And that's fiction. That's completely wrong. When someone has given you power of attorney or given power of attorney to anyone, and they die, one of the things that dies with them is any power of attorney that they gave out. So all powers of attorney cease to exist once the person ceases to exist, once the person dies. And then there are problems with powers of attorney even when the person's still alive. If the person now who gave the power of attorney is what you call incompetent, and they're not legally able to make decisions for themselves anymore, does the power of attorney have the durability to continue even though they're incompetent? Most powers of attorney do have that durability quality to them. They're called durable powers of attorney, and they endure the incapacity or the incompetence of the giver, but they do not endure, they're never tough enough to endure the death. At death, the person who has power of attorney is out of the picture. Perhaps that same person is the executor in the will, and that power is not vested in them until they probate the will, which is not a complicated process. It takes about 15 minutes. People believe it takes months to probate. No, to complete an estate might take months or even years, but to probate a will just means going to the courthouse and getting appointed as an executor or executrix. It takes about 15 minutes, provided there's no huge objection going on by anybody in the story, any family member. If you die without a will, then it's much more difficult. You have to petition the court to appoint an administrator, which often might be a family member, but if the family members aren't getting along, it might be an independent individual, such as an attorney that the court finds to appoint as the administrator. So please let's understand that powers of attorney are unique legal documents that give unique powers to the person receiving them. Powers of attorney also can be revoked at any time, just like a will can be changed at any time. Powers of attorney can be revoked at any time. That's a problem when it happens. We've had a situation where that caused a disaster in our company, but really nobody did anything wrong. We couldn't stop the giver of the power of attorney from revoking it. It's just like changing a will, as I said. But we need to understand the difference between these documents. And really, we need to understand it before we list a property. So I'm going to ask if Christina is here now. Did you make it to your desk?
I'm here.
Christina? Welcome. Okay. We got report that you were walking down the hallway in the office, so we knew you were coming shortly. So anyway, let's talk about finding out who the owner of a property is. When we get called up and we sit down with people who tell us that they're owners of property, we tend to just take their word for it. Well, not that people lie, but people may not understand that they may not be the owner of property, or that there may be more than one owner of the property, and you need to know that you need to deal with all the owners of the property. And there's different forms of ownership. There's the common ownership for husband and wives, called tenants by the entirety. There's a lot of partners in real estate. Those are called tenants in common. Two brothers own a piece of real estate together, or two friends. And then there's this owning with someone else and having a right of survivorship. That's a fascinating way of owning real estate, because joint tenants with the right of survivorship, and for that matter, tenants by the entirety, which is reserved for a husband and a wife. I used to say reserved for a man and a woman, but I can't say that anymore. A man and a woman who are married. Now 2 men and 2 women could be married. That's what the Supreme Court did a few years ago when they said that same-sex marriage was legal everywhere in the land. You now have situations where you have tenants by the entirety and joint tenants with the right of survivorship. And some of the owners of the real estate may have a will. And when they die, everybody looks to the will. But before you look to the will, you have to look to the title, to the way the deed is set up. If the deed is set up as joint tenants with the right of survivorship, doesn't matter what the will says. The individual could have left everything to their church. But if they had a deed with joint tenants right of survivorship or tenants by the entirety, the moment they die, no probate, no anything, the title is now vested in the survivor. So that's an interesting concept that, quote, the deed trumps the will, so to speak. The deed takes precedence. And these are legal strategies that people do when they acquire real estate. And there are also legal strategies that happen when people do some estate planning. Here's a suggestion for everyone on the call. If you're selling real estate to an older couple who are married, maybe they're in their 70s and they sell their houses. Maybe you got both listings. Maybe they're each widows, widower, and they sold their houses, and you got both listings. Maybe you sold 2 houses in Springfield Township for $300,000 each. You managed to get 2 listings. You're on top of the world. They got 2 transactions from this newly married older couple. And now they are buying a $600,000 house in some luxury over 55 community, maybe on the golf course somewhere. And you now get a 3rd transaction. You sold their 2 houses, now you're selling them the new house for $600,000. And a lot of times that married couple, while they're married, may not wish to take title to the property as tenants by the entirety, because they each have their $300,000 investment in the property, and they may have families, grown children, grandchildren, and they may have intended to leave that $300,000 equity to their children in their will. And they may have a will that says everything I have goes to my children. Well, if they buy the new $600,000 property, tenants by the entirety, and then one of them, God forbid, dies, the $300,000 equity does not end up with their children, according to the will, but it ends up with the survivor, the surviving spouse. And that maybe wasn't what they were intending. So that's a topic you may want to discuss. Always advise them to get an attorney, an estate attorney if possible, before they take title. Sometimes the title companies even ask. Title companies usually assume that husbands and wives are taking title, tenants by the entirety. But if it's not the case, husbands and wives are allowed to take title, tenants in common, or they can even reserve life estates for themselves and things like that. There's other forms of ownership that get legally complicated, but that can accomplish someone's intentions towards the end of their lives, other than just the tenants by the entirety. It would be kind of silly for a husband and wife to take title, joint tenants with the right of survivorship. They could, but it would be kind of pointless for them. When you're dealing with that situation, or any situation, how about this one? Very more common than maybe the older couple who have gotten married and they both have families because they were divorced or widowed. How about this one? You have a young couple who's not yet married. And how are they going to take title to the property? Well, they cannot take it tenants by the entirety because they're not married. So they must choose between tenants in common or joint tenants with the right of survivorship. And that's an interesting question. Do they intend to get married, for instance? Maybe they're engaged and they're buying the property together, 3 months. They're making settlement 3 months before the wedding. Maybe you have family members of friends of yours. Maybe you're going to be going to the wedding. So one of the things we advise is that after legally advise, I'm not a lawyer.
I'm looking into.
Lawyers would advise that young couples who are not married when they buy real estate, if they eventually get, if you're not asking a question, please be on mute. So young couples who buy real estate before they're married, after they get married, they actually probably should turn the title into a tenants by the entirety title. It doesn't change the mortgage or anything like that, but it's a legal step that has to be taken. It might cost a few $100s to get a lawyer to draw up the new deed. Years ago, when I started in real estate, titles companies would do this as a courtesy, but for legal reasons, they don't do it anymore. So you got to get a lawyer to draw up the deed, and then you have to record the new deed. So, a recording costs maybe $100, $200. It's a good wedding gift if you go to the wedding. It may be a little tacky, but you could do that. So at this point, Christina, do you want to say anything, or are there any questions coming in?
I don't see any questions, and I'm not sure what you want me to add, but I'm ready to help if you need me.
Okay, all right. So let's go back to you're going on a listing, and you want to make sure that you are sitting down with the legal owners of the property. Everybody's going to tell me that they check public records. Well, there's been a little bit of chatter, by the way, on closed Facebook pages recently. Public records, especially in Delaware County, but even in Chester County, are notoriously inaccurate on whatever data they supply. Maybe they got the right property assessment. Maybe they have the right address of the property, but they often do not have the right ownership, and there may be other problems with the public record. They surely don't have the right zoning. They never have the right zoning. Remember, the only way you find out the zoning of a property, I'm digressing here, is by going to the municipality, the township, the borough, or the city. The county creates the public records, and they do not know what the zoning on the property is. So never get zoning. That's another topic. It's a digression, but never get zoning from the public records. So one of the things public records show is who the owners of the property are. And that ownership that you see in public records may or may not be correct. Let me give you a typical example where they are not correct. Okay, so you get called up by your mother, who says, our neighbor Mary, and you know Mary because you grew up in, Mary's been there for 40, 50 years. Your mother and the house she's in has been there for 50 years, is the house you grew up in, and Mary is your old neighbor. And your mother calls you up to say, Mary is finally ready to list her house. Remember, her husband John died 8 years ago. And you say to Mom, sure, I remember. He was, we called him Uncle John. I played with his kids. I was at John's funeral 8 years ago. I remember when he died. So Mary has finally decided that she's going to sell the property, maybe move into a life care facility, a senior housing. Maybe she's going to move, to another state to be with one of her children, whatever it is. Mary is ready to sell. And Mary's going to list with the most wonderful realtor in the world, you. She's going to list with you because she knows you from childhood. She trusts you. She's good friends with your mother. And you call her up and you get an appointment to go over to the house to talk to her about listing her home. Now, before you go to Mary's house, you go to the public records. And you look in the public records and it gives the tax assessment address to the property. Don't believe the zoning, Yeah, but one of the things it's going to give you in the public records is the ownership. And don't be surprised if when you look at the ownership, it says John J. and Mary I. Smith. And that's their names. John was John Smith, his wife's Mary. Okay. So you're looking at the public records. And there it is. The public records show that it's owned by these two people, John and Mary Smith. And you knew John. Okay. But there's something about John right now that makes it impossible for him to own real estate. What is it? He's dead. He's 6 foot under, or he's ashes. You went to his funeral. Dead people, please understand this, because I see it all the time. Dead people cannot own real estate. Dead people cannot sell real estate. So while the MLS may auto-populate your listing with John and Mary Smith as the owners, John's not going to be able to sign. He's dead. He's been dead for 8 years. Not only is he not going to be able to sign, but his executor probably has no power anymore, even if he had an executor. He's not entitled to the property. He doesn't own it. He doesn't need to sign. He can't sign. He's not there. But the public records say that he owns it. So what did we just find out in this little story here? The public records are wrong. Who owns this property? Well, I think Mary Smith owns the property, all by her lonesome self. And the reason is, the moment John's heart stopped beating 8 years ago when he had the heart attack and he died, okay, the moment he died, since they owned the property and the deed said, and still says, if you pull the deed, it still says John J. Smith and Mary I. Smith, tenants by the entirety. Because it was tenants by the entirety, the moment John died, title then vested in his wife, his surviving wife, Mary. Okay, there's only one exception to that, by the way. When I tell you what that exception is, it's going to save a life. Now, the life I save right now, only you know whose life I'm about to save. Okay? If you own real estate tenants by the entirety with your spouse and they die, you automatically own the entire piece of real estate. Unless the cause of their death is your hand, meaning you murder them. If you kill your spouse, you don't own the house. By the way, we had that happen in the transaction. John Harriet, unfortunately, is not on this call. Anybody wants to pray for John Harriet? He's having some health issues. That's great. But John Harriet actually had that listing where the husband had killed his wife in the house. And it was a title problem because you don't then get the other half of the house. You end up owning only the moment you kill your spouse, it's as though you own the property, tenants in common. And you got to deal with your spouse's estate at that point, not to mention you're going to jail, which is exactly what happened in the real life story we had. And then to make matters complicated, in our real life story, the murdering husband actually died in prison after a few years. So anyway, it causes title problems. So yes, so I don't know whose life I just saved by telling you that, but normally when your spouse dies, if you own the property tenants by the entirety, you now own the entire property. Also, if there's any liens on the property, the liens carry forward as well, such as a mortgage lien or something like that. So what I just demonstrated to you is that the public records can be wrong when it comes to ownership. Okay? And that just doesn't happen when one spouse dies and they never get around to drawing up a new deed. By the way, after John died, Mary could have gone to her lawyer and gotten a new deed drawn up just in her name. She could have done that, but she didn't. She saved the money. She didn't know she was supposed to. But it's not an impediment to her selling the property, provided she can show a death certificate for her husband who died 8 years ago. but also that she can show that any estate taxes were paid. Therein lies a piece of information that I'm going to keep coming back to. If you're selling real estate that was owned by someone who's now dead, you have to make sure the Pennsylvania estate taxes are paid, or you're not getting through settlement. You have to file a return, pay the taxes, and have proof from the state of Pennsylvania that the taxes are paid, which takes months to do that. Once in a while, in the old days, title companies used to accept letters from attorneys saying, here's a copy to return, it's paid, or here's a copy to return, send the money in. But most of the time, the title company is going to want to escrow. You know how you hear title companies never escrow? Well, that's not true. They will always escrow for estate taxes to the state of Pennsylvania to get you through settlement for an estate. And then when the executor or administrator finally pays the tax or proves that the tax is paid, they show that to the title company, and the title company then releases the escrow to the estate. Then it can be distributed amongst the heirs. So, that's an important step that we're going to come back to that really prompted me to have this topic for the day, this idea of trying to sell the property of an estate where you don't satisfy the title company that the estate taxes are paid. So even if John died 8 years ago, you still have to go through that situation. Okay, so now I want to get back to this point that the public records in the case of John and Mary Smith were incorrect. I always laugh when I see a listing in the MLS and the name of the owner is listed as the owner of record. And why would a listing real estate agent put owner of record as the owner? And believe it or not, the reason is, there could be a few reasons. I get the reason that it's a celebrity who owns the house and they want to keep that person's name secret. Well, if you look at the MLS and it says owner of record, and it's Allen Iverson, the retired the Sixer basketball player. If you look in the tax records, it's going to show that Allen Iverson owns the property. So you're not hiding that from anyone. If you put on a record, any real estate professional who can check the tax records and see that. So I always think that's a funny reason. People say I put on a record because I wanted to keep the owner's name secret. Well, it's in public record. That's what owner of record means. And it's on the deed filed at the courthouse. And that's where the tax data that you look at gets that owner's name right from the deed at the courthouse. So that's not a really good reason. But a very common reason for people to have owner
Sorry, I
of record.
forgot I had a broker's.
Okay, a real common reason for people to have owner of record is because title is in flux. We talked about one yesterday where the owner of the property, who now owns it, bought the property at a mortgage foreclosure sheriff sale, and the tax records still show the old owners. Someone's buying the property and they're flipping the property. They're turning around and selling it right away, or something like that. Or they own the property in their own name, but they're forming an LLC or something like that. And they don't yet have the new ownership name established. And that is a huge, huge problem for anyone who's listing, selling, or trying to go to settlement in one of these houses. But the idea of substituting the phrase owner of record when the title to the property is on the cusp, is in transition, is changing, is exactly wrong. You see, when they put owner of record, it's an old term that is wrong. I can tell you why they used it. They used it when I started in real estate correctly. I even maybe 39 years ago when I started, maybe wrote owner of record for an owner, and I did that correctly. And here's why. You see, if you sat down with Mary in that story of your mother's neighbor, Mary, that you've known your whole life. You sit down with her, she's widowed. You know that she owns the property, right? And Mary's got the ability to sign the listing contract, the agreement of sale, and the deed for that matter. But you're saying to yourself, well, the MLS is auto-populating John J. Smith and Mary I. Smith. So you do something foolish. You say, well, since the MLS is getting it wrong, you're going to change it to owner of record. Well, as soon as you do that, you get it wrong again, because the owner of record is John J. Smith and Mary I. Smith. You see, you don't mean to say owner of record, you mean to say actual owner. And the actual owner is Mary Smith, Mary I. Smith. So every agent who ever puts owner of record in the MLS means to say exactly the opposite. They mean to say not the owner of record. Isn't that fascinating? In my early days, we didn't have access to the public records when we were trying to sell a new listing that just came on the market on a Saturday. We didn't even have online MLS. We had MLS books that came out every 2 weeks. And we knew the listing agent because we knew the sign on the lawn. We made an appointment to show the property. We never dreamed we'd be selling it. And we want to write an agreement of sale up, and we didn't know the owner's name. We had no database to go to find the owner's name because the courthouse was closed. So, and we tried calling the listing agent to say, what's the owner's name? We couldn't get them, but we didn't want to stop that from us writing an offer. So we took a chance, because 90% of the time, the owner of record is the owner. No one's died. They still own the property. So putting owner of record made sense 40 years ago. It doesn't make sense today. Okay, so please don't ever write on an agreement of sale owner of record, please. And don't ever put in the MLS owner of record, and don't ever put on a listing contract owner of record. So now let's go back to getting a listing contract signed. You need to make sure that the person you're dealing with is legally able to sell the property. So if Mary is in a nursing home and you get the call from your mother saying, Mary's been in a nursing home for 6 months and her daughter, Jane, has power of attorney and she wants to list and sell the house, you meet with the daughter, Jane. Well, you sit down with Jane and Jane says, I have power of attorney for my mother. Okay, number one, the deed still says John J. Smith and Mary I. Smith. Okay, but we know that title rests with Mary I. Smith. And Mary's in a nursing home, and now you're meeting with her daughter, Jane, who says to you she's power of attorney. Well, is she power of attorney? What do you need to prove that she's power of attorney? You need a copy of the power of attorney. Now, you get a copy of that power of attorney. It used to be you had to make a copy of it on a copy machine. Now you can even make a copy of it on your phone. What should you do with that copy? Well, you got to keep it in the file along with your listing, because you don't have a listing valid unless you have proof that the person has power of attorney. But you're not sure if that power of attorney is valid, is correctly completed, is notarized correctly. Believe it or not, the counties have notary rules for accepting powers of attorney. So you want to make sure that that power of attorney is going to be able to be used in order to convey titles. So one of the ways you can do that is by getting an expert opinion as to whether or not the power of attorney is sufficient and valid to transfer property. So you would ask a title company that question by giving a title company. So we all have our trusted title company called KPSS. So you take it to the wonderful people at KPSS and you ask them if they could check this out. And they'll say, oh, I'll send it upstairs or send it up to underwriting and I'll let them give an opinion, even though chances are they're never going to they're not going to be the ones issuing the title. It would be nice if we sell it in-house and they get the title, but some other brokerage company may sell the house and some other title company will get it. But if our title company can say that the power of attorney is correct, that's good enough. I once had mom and dad still alive, both in a life care facility. Youngest daughter had power of attorney, youngest daughter out of 5 children. She was unmarried. She had 2 powers of attorney. I got both copies. I took them to KPSS. KPSS looked at them and reviewed them and said they're not sufficient. They were insufficient to transfer title. So the daughter, the family, the daughter who had power of attorney went and got her parents to sign 2 correct powers of attorney, so she would have power to list the property, sign an agreement of sale, and go to settlement. Ultimately, we succeeded in doing all 3 of those, and we made a sale. Even though mom and dad, we never met mom and dad. To this day, I haven't met mom and dad. I don't even know if they're still alive. I know what life care facility they were in. It's the one next to Riddle Memorial Hospital. That's where they were, Riddle Village. And we succeeded in selling their home because we did our homework. You see, if I didn't do my homework when I was taking the listing, I would be giving a title company at the last minute the copies of the power of attorney, only to find out that
Hey,
they were
Chris.
insufficient, and it would be.
I'm good. How are you?
Paul, can you please put yourself on mute? Thank you. Okay. All right. So anyway, that is what you do when, number one, if someone has power of attorney, you verify that they have it, you get a copy of it, and then you run it by a title company to make sure it's sufficient for you to list the property. So, okay. So that's one thing you want to do. And by the way, anybody who has power of attorney is obligated to fill out a seller's disclosure form. Don't think that someone who is a power of attorney is not obligated to fill that. They are obligated. An estate is not obligated. An executive is not obligated to fill out a seller's disclosure form, but someone with power of attorney is. Okay. Now, when you, let's change the scenario. Your mother calls you up and says, oh, Mary passed away. And you go to Mary's funeral, and next thing you know, your mother's calling you up a month later and saying, Jane, her oldest daughter, your former playmate, wants to list a house, and she's the executrix of the estate. Well, now you're going to meet with Jane and you're going to say, oh, you're the executrix. Did you probate the will? And if she says no, well, she's got to probate the will, which I say is only a 15-minute process, assuming there was a will. So Jane then is going to get appointed as the executor of the estate when she probates the will, and she's going to get what's called a short certificate. And you need to get a copy of that short certificate proving that she has the legal ability to list and sell the property. Okay, and if mom didn't ever fill out a will, and Jane went to the court with her siblings, she petitioned to be the administrator, and they appointed her as the administrator. Instead of getting what's called a short certificate, she gets letters of administration, and that's what you need. You need the document from the court proving that the person you're dealing with, be they an executor or executrix, has the short certificate, or being an administrator or administratrix, being that they have the letters of testamentary appointing them as the administrator of the estate. And then you can proceed. But remember, you're always going to have that estate tax problems. Don't forget that estate tax problem. Often when older people die, they don't have a mortgage on the house. And if it's a $300,000 house, it's $300,000 worth of equity. And, you know, there's plenty of money to escrow an estate tax. So the one we had last week, I think Marsha may be on the call. Marsha was the productivity coach, or the contract writing coach to help in this transaction. We had a situation where the title company was attempting to hold $28,000, and it turns out there wasn't even $28,000 worth of equity. So the title company, by the end of the day, realized that they were holding way too much money and they hold much less, and they were able to get through settlement by escrowing a small amount of money for the unpaid Pennsylvania estate tax. I'm talking Pennsylvania estate tax, not federal estate taxes. Most estates that you deal with don't have, you know, federal estate taxes because you're not dealing with multi-million-dollar properties, farms in the Midwest or something like that. So anyway, those are the things I wanted to point out to you. So I went over powers of attorney. I went over estates. I went over ownership. I went over public records being often wrong. So you need to verify, you must know who you are working with. If they formed an LLC, are they actually the person who can sign for the LLC? If it's a corporation, are they the person who can sign? You must get evidence of this because the title company is going to need it. And you don't want to be the listing agent with egg over your face at the last minute, not being able to do this or having to scurry at the last minute and maybe delay settlement. And if you're the buyer's agent, you don't want your buyer not being able to buy the property. Remember, there's everybody who has a deep understanding of the agreement of sale knows that paragraph 14 of the agreement of sale talks about title surveys and costs. But the point is, if a seller cannot give clear title to a property, the seller's not in default unless they lied about something. They simply just can't give title. And then the buyer gets their money back and they get their costs reimbursed to them, but they don't get the house. And when a buyer finds out that 3 days before settlement or 3 days after settlement that they can't buy the house, and whoopee, they get their money back, and whoopee, maybe they get their mortgage application costs and home inspection costs, $1,000 reimbursed to them. What good does it do if they don't get the house? So we as agents need to make sure that these legal hurdles are lined up correctly so we can get through settlement. The last thing I want to talk about is this thing called guardianship. Well, you see, a person who is competent, legally capable, can give power of attorney to someone else. Okay? And they can also take power of attorney away. They can revoke the power of attorney. But if they give power of attorney when they're competent and then they become incompetent, let's talk about, the most common situation, memory loss, Alzheimer's, dementia. So now the older person perhaps is no longer legally competent, but when they were competent, they gave power of attorney to their oldest daughter, Jane, in my old example there. And it was a good, well-written power of attorney. It can be recorded. And it's a durable power of attorney. It can endure the incapacity, the incompetence of Mary, who's now in the advanced stages of Alzheimer's. So it's going to work while she's alive to be able to transfer the property. But if she didn't give power of attorney to Jane, and then she goes into the nursing home, and then she has memory loss and advanced stages of dementia or Alzheimer's, it's too late to get her to sign a power of attorney. So how are you going to sell Mary's house? Well, she's not dead. Maybe if she died, you'd be able to sell it because then you'd have an estate and an executor. She's alive, and she never gave power of attorney to anyone when she was competent. So now what has to happen? You have to hire an attorney. You have to petition the court to get someone appointed as the legal guardian. It's called a guardianship. Okay. And now, after getting that person appointed as the legal guardian, the guardian does not have much power. The guardian can pay to feed the person, can pay their electric bills if they're still living in their house, can pay their medical bills for them and things like that. But guess what the guardian cannot do? The guardian cannot sell their major assets. In particular, they cannot sell their home without the court agreeing to the sale. So you then have to get an agreement of sale. The guardian can list the property, but the listing has to be contingent on court approval, and an agreement of sale to a guardian has to be contingent on court approval. And you go to the court and you get approval for the agreement of sale. And then when you finally sell the property, especially if it's at a different price than what was in the agreement, in the listing contract, you then have to get court approval yet again. And a lot of agents, they make that mistake once in their career when they deal with a guardianship. They think a guardianship is just like power of attorney. And as long as they take the guardianship, they give it to the title company says, yeah, this guardianship is in order. That's great. But the title company forgets to say you need a court order to transfer title. The guardianship doesn't give that power to the guardian. Okay, so those are the things I wanted to talk about today. And I want to open it up to Christina or to anyone else who has any questions or thoughts. Christina,
There are 2 questions or 3 questions, and I think it might be helpful to do sort of a quick summary review of what you've covered, because with a lot of stories and examples in between, I don't know that anybody may have gotten a little bit.
Who, me?
Confused.
I told stories and I confused people?
Yeah,
Oh,
I'm just
come on,
wondering,
Christina.
maybe, right? So you talked about estates where, and there is a question from Holly, you know, what do you do when the public record says the owner's name, but you know that person is deceased? And I think you hopefully heard Dominic answer in the course of the examples that you do not repeat and believe what the public records say when you know they are incorrect. You know better because you are sitting there in real life with the people or family members, executrix, administrator, whatever. So you use in your listing contract what you know to be correct. You can change what shows up in the MLS when you're entering the listing, and you have to make sure, the most important thing that Dominic's talking about is you have to make sure that the person you are talking to who is signing those papers is the person who has the correct authorization to do it. So
Yes.
you've got estates where you need to have, where the person is deceased, and you need to know that there is an executor or executrix appointed by the will, and that person has to have the short certificate to prove that. And there could be more than one executor or executrix, and then you have to deal with all of them. Usually there is one. And it could be, if the person is still alive but has assigned power of attorney to somebody else, then you need to see that power of attorney. It needs to be reviewed and approved by the title company before they will have settlement. They're not all powers of attorney are satisfactory today in Pennsylvania. And you're going to need an original copy of that power of attorney because it will have to be recorded at the time of settlement. And a power of attorney does not survive the death of the person who gave the power of attorney, right? So it only works when somebody is alive. Once they are deceased, it stops.
Yeah.
And then you have the guardianship or custodianship, and that is when somebody is alive but is not capable or competent to assign power of attorney, and the court has to step in. And this is, Maureen asked a question. She said, is that the orphans court? I believe that's correct. Right, the orphans court.
I believe it's
assign a
correct.
Guardianship, right?
It doesn't
And
matter. It's all the court. You go to the courthouse, they'll
right.
tell you where
You go
to,
to
you
the
walk
court,
up the
they'll
halls and you ask someone where you need to
you
go.
go.
You tell them your problem
Yeah.
and they tell you where you go.
Yeah, and the court is, you know, that is the state taking care of or protecting this person's interest because they're not capable, and they do that by having, you know, approving or assigning a guardian, and sometimes multiple guardians to take care of this person's affairs.
Christina, Britney Spears' father is her
Right.
guardian. He's
Yeah,
resigning
right.
as we speak.
One very prominent example. But you know, even that guardian, even though they are empowered to do certain things, cannot dispose of property without the court's approval. Otherwise, a guardian could take advantage of the person they're supposed to take care of. So
So Christina, let me do Holly's question. Holly's question is, so what do we do when public record says John Doe, but it should say the estate of John Doe? Well, first of all, if it's the situation, did you want to say something more, Christina?
the public records are never going to say estate of.
Right. I'm going to get to that. Okay, Holly. Let's say this. Okay. First of all, in my example, where Mary Smith survives her husband by 8 years and she's alive, 99% of the time, you look in the public records and it's going to say John J. Smith and Mary I. Smith. You need to look at a copy of the deed to see that it says tenants by the entirety. The deeds actually say that, but 99.9% of the time, husbands and wives, when they took title to the property, had it by tenants by the entirety. So when you see their names, you can feel pretty confident that they own the tenants by the entirety. If you want to be totally anal, okay, get a copy of the deed and verify that it said tenants by the entireties. But John is now dead, so now you know total 100% title is vested in Mary. Now, if you're dealing with an executor, as Christina reiterated and I said, if you're dealing with an executor, the public records is going to say that John J. Smith and Mary I. Smith own the property, or that Mary Smith owns the property. Well, they are wrong. And as Christina points out, they never get corrected to say estate of, which brings me to something that we didn't talk about, Christina. I'm going to let you do it. How do you fill in the agreement of sale for the seller's name? How do you fill in the listing contract for the seller's name, or even the seller's disclosure? If they are going to fill out, which I hope they will fill out a seller disclosure form, even though they're not required to. How do you list the name of the seller when it's an estate? And then I'll do power of attorney after you do estate. You're muted, Christina.
If you know that the owner of the property is deceased, then, so let's say John owns a property, and John is deceased, then you're going to write the seller's name as estate of John. And separately, you're going to figure out who's going to sign. And this only gets confusing because we do it electronically, and we get confused because the electronic forms automatically put what we fill in for seller estate of as the signer's name. And we have to manipulate our electronic system a little bit because we know that somebody else is signing for the estate of John Smith. We know it's the executor or administrator, and it is that individual person signing with their own personal name. They're not going to sign estate of John. They're going to sign their own name and maybe comma executor.
Christina, is the system capable?
Yeah.
Does it have enough data points to be able to put?
Yeah, you can do it.
Estate of John Smith by Jane Smith.
No, so if you do
executor.
that, it gets even a little bit more confusing. You can make it say that in print, but that confuses the signing a little bit more. So you do have to manipulate a little bit how the electronic system is going to show it correctly. And you might even, have to resort to taking documents, out of DocuSign, filling them out as a PDF, and then putting them back in for signatures, or, getting them signed by hand. But it's not really terribly difficult. You just have to use your brain a little bit, because the electronic DocuSign doesn't automatically do it right.
Christina, can I do what I would say is the correct thing to write on a line on the seller, for the seller name on the agreement of sale, and for that matter, the listing contract? Estate of John J. Smith by Jane Doe, comma, executrix, or comma, administratrix, if it's Jane Doe, if it's a boy.
If you can,
that's the best way to name the seller of the property.
Mm-hmm.
If you don't want to, you just do estate of John J. Smith. That's it. And then when you get to the signature line, you put Jane Doe, comma, executrix for the estate of John J. Smith.
One of the ways I've done it that works pretty well is to, in DocuSign, for instance, you act as though there are two sellers, and the seller one is estate of John Smith, and seller two, that second line that will appear, is, Jane Smith, comma, executrix.
Oh,
so
clever.
That makes the forms right, but it depends. You have to sort of try it and then see how it prints, how it shows up on the actual form, and it will be a little bit more difficult sometimes if you have more names or a different situation than the estate. It doesn't always work out that neatly, but if you do that in this two sellers, the estate of isn't actually going to have an electronic signature. Only the second one, Jane Smith Executrix, is going to have an email and a signature. So that's just one idea. But the electronic tweaking behind this, I don't think is what we need to talk about today, as long as you get it right on the contract, one way or another.
Christina, I assume the exact same challenge goes for powers of attorney, because if Mary Smith is alive, she gave you power of attorney, you would sign Mary I. Smith by, Jane Doe, comma, power of attorney, or attorney in fact for John. So, there's a couple of ways of doing that.
It's similar. And one of the things that works better in the electronic system is you always have to put the name first. So if you ever signed at settlement on behalf of a seller, the title companies tell you to sign your name, agent for. And that basically is the same way they're going to want most powers of attorney or executors, executrixes to sign as well. And that's how you can enter their name in the electronic system, that it will make more sense is if you put the name first. So don't say by Jane Smith. Instead, you do Jane Smith, comma, and write it that way.
Comma,
POA,
POA,
executrix, yeah.
or attorney in fact.
Yeah.
Or,
Just
right.
don't let the electronic don't let DocuSign or .loop confuse you about what the facts are. You need to make the contract say the correct thing. You had another question from Mary Pat. Do you need to go through probate when one spouse is still alive? And if I could short this answer, because I know we're short on time. If you had a husband and wife and you could find out in the deed they owned it as tenants by the entirety, then that is not going to have to go through probate, because it's just automatically instantly passes from the deceased spouse to entirety to the surviving spouse. So that's not going to go through probate. But if it's not tenants by the entirety, and if there is a will, it's probate. That's pretty fast.
No, but okay, but let me just finish. As you say, joint tenants with survivorship or tenants by the entirety doesn't deal with a will. We don't care about a will. We don't care about probate. The deed trumps the will. The deed trumps probate. The title is automatically, the moment the heart stops, as long as you didn't kill them, the moment the heart stops, that title rests in the new person. No probate, easy as pie. You got to show a death certificate, and you probably have to show that the estate taxes have been paid. That's the only thing, but no probate.
And Mary Pat makes another good point, which is that you can add someone to the DocuSign envelope without adding them to the whole room. So you don't have to give them a role as seller. You can just add their name and email as a signer and place their signature any place you want. And that is another very good way to work around some of these complications, especially when you have more than one person or the names are difficult. You can print whatever you want for seller in your DocuSign room, and it will populate everywhere. So you could populate estate of through all of your documents, but then you can place the signer, any signer, by just adding a name and email to an envelope. Yeah.
Can I add something?
Go ahead, Maureen.
Yeah. Just to let people know, most of the time, by the time the title company gets a hold of things, they probably will still ask if it's John Doe and Mary is the executrix. They probably will still ask for John Doe's death certificate. So it's not a bad idea to get both. I mean, to get all the death certificates that are in existence.
Absolutely. You're still
At
going
some
to
point, they're going to ask for
Absolutely.
that. And sometimes it's closer to the end, and then you have to scramble because they can't find it. And then they have to go to the funeral home and blah, blah, blah. So better to just ask for whatever death certificates there are. If John and Mary both died and Susie is the executrix, and Mary died last, they're still going to need John's.
Right.
Absolutely,
And,
you're right.
and Maureen, that is so wonderful that you point that out. And that's the whole purpose of this class. The whole purpose of this class is so that nobody's going to get caught waiting until the end. If you have this knowledge is power. You're going to make sure you get both of those death certificates probably at the time you list the property. It's so
Good.
smart to do that.
Yeah. To answer, Holly had another question quickly of why would estate taxes still have to be paid if a spouse is still alive? So the spouse who passes, even if they leave a surviving spouse, they might have an estate that is larger than that property that you're talking about. So the one property, the one house property they
Right.
own as tenants by the entirety may pass automatically to the surviving spouse, but they may have a much larger estate and subject to estate taxes. So anytime you are dealing with an estate, you must be prepared for this question of estate taxes. Even if they say they've been through probate, they have a short certificate, that's good, you need that to list, but that does not answer the question about estate taxes, which you will have to answer before settlement. And don't make assumptions. Dominic gave an example earlier where the title company, because they didn't have enough information, they were prepared to hold estate taxes, assuming the entire sale price of the house was, the entire proceeds from that sale was it was like all equity if there was no mortgage, and they were going to hold a percentage of that, but it was going to be a huge amount of money in escrow to pay the potential estate taxes. They got more information and showed that the estate, the remaining equity of the estate, was really very small, and so they ended up having to hold much less. But the reverse can happen also. I recently sold an estate for $70,000. Sorry, the property was for $70,000, but the seller's estate was much, much larger than that. And so in fact, the seller informed the title company, you're going to have to hold almost all of the proceeds to pay the inheritance tax, because the inheritance tax is much larger than the proceeds of this property. So 2/3 of the potential proceeds were held in
The sooner you start communicating about this problem with the sellers, executors, administrators, the sooner you involve, hopefully they have a lawyer, the sooner you communicate with the title company, you can take care of these problems well in advance of settlement, because the chances of getting a tax return filed and accepted by the title company is not going to happen, because they just don't want to see a tax return, and they'll even pay what's on the tax return, but they're going to still escrow a lot of money because they need the receipt, which takes about 2 months to come from the state, showing that the estate taxes have been paid and the state has accepted it.
And another
So-
good thing, just to make sure that you get the attorney's contact information so that you can introduce yourself either
Sure.
by email or on phone,
Sure.
so that you build a rapport there, so that at the end, if there's something needed, you've already gotten that rapport going. And don't take for granted that the attorney is going to talk to the title company and vice versa. Make sure that, you let the attorney know that he might want to touch base with the title company about the estate tax, about the things that are coming up, because they can talk in the vernacular a little bit easier than some of us can.
There's no such thing as a dumb question when you're trying to get things accomplished. So ask as many dumb questions as you can as early as possible. I want to. Okay, Christina,
well,
go ahead.
we're over time, and there's another question that's a little bit off topic on zoning that I want to say to Doug that we'll come back to. If you can stay on a few minutes. And Vince just asked a question, or recommended that you also ask about state provided health care that may need to be paid back out of the estate.
Oh, that's great.
Talk about it, where the
That's wonderful.
complications show up. Yeah.
We can get really
Absolutely.
complicated. When it comes to Medicaid, if the person was on Medicaid, there's a 5-year look back to make sure that they didn't divest themselves of any assets, like giving houses to their kids within the previous 5 years. It's very complicated, but great point,
That's a great
Vince.
point.
There may be
And
a county lien that will have to be paid.
And I wanted to say one other thing about guardianships. We said that those need court approval to dispose of property. And what that means in practical terms, if you're the listing agent and you're looking at an agreement of sale, you need time to get court approval, which is like getting court approval in a bankruptcy or any other complicated situation. You have to allow for that, which is going to take you more than 30 days just to make sure you can get a court date. And that's assuming you have an estate attorney who's really, or an elder law attorney or whatever, who is really on the ball and able to act quickly. So build into your contract enough time to get that approval, or your seller will not be able to convey title.
Okay, so
That's that.
now we're finished. on the topics we had, unless anyone else has a question before we get to the bonus question of Doug Scullin about zoning.
I'll
So-
take a stab at it, unless there are any other
Okay.
questions on estates, and we're
Well-
over time, so if anybody
Well,
has
let
to
me
leave,
say
we
this, if you
understand.
want to stay and you want to hear about zoning, I think it's critically important. It's almost a topic for
In itself.
another breakfast with your broker. And I think that's what we should do. We should cover it again in the future. But by just saying this, Doug, if we read paragraph 6 of the agreement of sale, we read that failure of this agreement to contain the zoning classification makes the agreement voidable at the option of the buyer, not the seller. Now, there's a huge exception to that law. That law was written twice, once in 1990, I was there, and once in 1991. I was there for the revision that PAR succeeded in getting. Because in 1990, it said if you didn't have the zoning, the agreement of sale was void, and we got it changed to avoidable at the option of the buyer. Now, the huge exception is except if the family is a single family home. And people get confused. Townhouses, condominiums, they're single family homes. I don't know how many people use stuff into a condominium. They're still single family homes. So 95% of the time, Doug, we are supposed to, get this, leave the zoning classification blank on the agreement of sale. Writing the word residential is always wrong, and yet you write it all the time and nothing bad happens, but it's incorrect, it's wrong. Zoning classifications are put on by municipalities, townships, boroughs, and cities. They look like R1, R2, R3, R4, R5, C1, C2, C3, I this, A that, all agriculture apartments, all this, okay? They are the zoning classifications, okay? And every township defines their zoning classification uniquely to that township. So R1 or R2 in my township is different than R1 and R2 in your township. In my township, you need an acre. In your township, you may only need a quarter acre for R1. So don't put residential. It's always wrong, but you don't need to put anything if it's a single family home. Just leave it blank. But the only time you must put the zoning classification is when it's not a single family residential. You're selling a gas station, you're selling an office building, you're selling a pizza shop, you're selling a 2-unit residential building, a 3-unit, a triplex, a quadruplex. You must have the zoning classification or the buyer can void it. And the only way you get the correct zoning classification is by going to the zoning map at the township, calling the township, asking the zoning officer what that zoning classification is. Doug, I'm sorry, you said it's interesting that the tax records are often wrong when it comes to zoning. No, you misunderstood me. They're always wrong. The zoning you see in the MLS in tax data is always wrong, not often wrong, but always wrong. The only time the correct zoning classification is correct is when the listing agent got off their duff and found out what the correct zoning classification was and entered it in the MLS. And that's my next point. When you are a listing agent on an office building, a duplex, a triplex, a quadruplex, anything that's not a single family home, you must get the zoning classification correct and enter it in the MLS correctly when you list the property. Thank you. Anybody else?
Dominic, this is Paul. So,
Yes.
but doesn't the language essentially say that without a classification there, the agreement is potentially void?
No, except if it's a single family home.
Except if it's a single family.
So
And
Paul,
95% of the time, we're selling single family homes. I can
Right.
read it to you.
so if the property is owned solely or primarily single family residential, you don't need to put anything, and the contract is not voidable because of that. However, if the zoning is anything other than solely or primarily single family residential, it is voidable by the buyer, not by the seller, by the buyer. So what Dominic is saying is when you have to really be careful about this is when you represent a seller of a property that is zoned anything else, anything other.
Christina and
single-family
everyone,
residential.
there was a property in Lebanon County. The sale price was $22 million. It was in a signed, executed agreement of sale. The buyers backed out at the very last minute. because, and they used as their excuse that there was no zoning classification in the agreement of sale. It was not zoned single-family residential. It was hundreds of acres. Anyway, the lawsuit hit the fan, and I was called, I never had to go testify, to be an expert witness. The listing agent and the agent who didn't put the zoning classification in was hung by his fingernails. He went out of business. His entire E&O policy couldn't even handle the claim because the seller, the buyer said, oh, we'll continue with the sale if you sell it to us for $4 million. They had an agreement to sell for $22 million. They were willing to pay $4 million. And the courts had to let the buyers out of the agreement of sale and give them their $200,000 deposit money back because the agreement of sale failed to contain the zoning classification. It is a be all and end all if it's not a single family residential property you're selling, and it's totally meaningless and you don't have to ever worry about it if you're selling a single family residential home.
Yeah.
How's that?
I might rather be incorrect than take the chance. But just, you know,
Everybody puts residential in and nobody gets in trouble for it because it doesn't cause a problem, but it's not correct. But you can, if you want to keep putting residential in, go ahead. It's not a zoning classification. You look it up, it's going to say R1, R2, R3. You're going to
Yeah.
fill that in, and that's going to be correct, and that's not going to matter either.
right. Thank you, guys.
Doug says, so if you're the listing agent and you receive an agreement with the zoning included, must you have that removed?
Well, we got to talk about it. If it's single family residential and they wrote residential, no, you're okay. All right. If it's incorrect, if they put R4 when it's R2, then yes, you have to correct it before you sign the agreement of sale. Okay. And you want to make sure, here's the bottom line, as a listing agent, you want to make sure that if it's not a single family home, you have the correct zoning classification in there. Otherwise, your seller can lose his sale the day before settlement. I just told you about a $22 million property that had that happen to them. So, yeah, I wouldn't worry. I mean, I would stop writing residential in. All you productivity coaches, contract people, Marsha, Mary Pat, if you're listening, stop having agents write residential. It's incorrect. You can write the words not applicable. You can leave it blank. That's more correct. Or you can be anal and go look up and find out that it's R2, R3, whatever it is. But why you would go through that trouble is beyond me.
And the looking up isn't looking at the public records. It's harder
Right.
than that because the public records information
You got to
is
go
not
to the
correct or not complete. So you've got to go to the municipality to find the zoning code. And you know, if you're on the buyer side, of course, theoretically, and even in fact, you know, you can use this in reverse. I represented a buyer once of a 3-unit property, you know, triplex, which we were not able to verify at the time we wrote the offer that 3 units were permitted. And we knew that if they were permitted, this property was probably not zoned single family residential. We did not fill in the zoning because I'm representing the buyer. The buyer had a contract that was now voidable if the zoning was anything else. And that was deliberate. The seller and the listing agent never caught it. But during our inspection period, we were able to verify the zoning was acceptable, and we went ahead with it.
And Christina, by
But
the way,
I protected the buyer.
yeah. And by the way, if I were a listing agent, I would have had the correct zoning classification in there, and I would have suggested that you use a form that PAR has called zoning verification form, and you could have done that too.
Yeah, yeah,
If you're a listing agent, you did okay as the buyer's agent.
yes.
Okay. We went over. Anything else? We gave the bonus. Now we don't have to have a class on zoning classification, but I can't stress how important that is.
Dominic, can I just say KW Media, please check your evites and remember the meet and greet Wednesday night from 4:30 to 7:30.
It's a free party. We're gonna have a good time.
Yep. Always.
It was a good time.
If you're in Brandywine Valley and you want to show up, don't tell them I said it. They can come
No.
too. The more the merrier.
All right, well, I think we're done. I don't see any more questions, so thanks for hanging in with us, everybody.
Okay, see you in 2 weeks. Have a
Thank
wonderful Labor Day, Labor Day, right? Wow, time flying. Summer's almost over. Okay, God bless everyone.
Dad, I'm going to give you a call in a second about something else.
Okay.